In this video, we will cover the last topic in this week's module, which is also our most complex, contract modifications under Article 2. What are the terms of a contract when the parties later agree to change the contract, to modify its terms? Contract modifications raise three potential issues, which will also serve as our roadmap for this and the next two videos. In this video, we'll start with the first of these issues, the UCC's abolition of the pre-existing duty rule. To understand contract modifications under Article 2, it is useful to start first with how the common law of contracts treats modifications, to better appreciate how the UCC deviates from the common law. Just as parties may agree to terms that form a contract, parties to an existing contract may later agree to modify or amend the terms of their contract. Under the common law, an agreement to modify an existing contract may be made in the same manner that the parties may make any other contract. Stated differently, modification of an existing contract is subject to the same general contract formation rules that we have already discussed. Recall, to form a contract under the common law requires mutual assent of the parties as measured by an objective standard of assent. That objective manifestation of mutual assent may come in the form of an offer and acceptance, but all we need is mutual assent. All we need to form a contract is for both parties to objectively manifest their intent to be bound to a deal, whether that intent is manifested through express words or through the conduct of the parties. Likewise, an agreement to modify an existing contract is measured by the same objective standard. Modification of an existing contract requires an objective manifestation of intent by each party, a manifestation of intent that a reasonable person would understand to mean that that party is assenting to the modified terms. But beyond mutual assent, remember that to make an agreement enforceable requires the exchange of consideration. Under the common law, the same is true of an agreement to modify an existing contract. When one party's obligations under a contract are modified, the agreement to modify those obligations is only enforceable if the agreement is supported by bargain for consideration by both sides. Stated differently, when an agreement to modify a contract changes only one of the parties' obligations under the contract, but leaves the other party's obligations unchanged, the agreement to modify is not enforceable because it's not supported by bargain for consideration. In particular, the other party's pre-existing legal duty under the contract cannot provide the consideration to support the first party's modified obligation, because the other party incurs no new legal detriment in having to perform an unmodified obligation that it was already legally obligated to perform. Under the common law, this is known as the pre-existing duty rule. Probably the most famous application of the common law's pre-existing duty rule was in the case Alaska Packers Association versus Domenico, which you may have covered in your study of the common law of contracts. In that case, a group of fishermen in California agreed to an employment contract to work on a fishing vessel bound for Alaska for the salmon fishing season. Once the vessel arrived in Alaska, however, the fishermen demanded higher compensation and threatened to cease work. Because the plaintiff employer would have been unable to hire other fishermen in time for the Alaska salmon harvest, the plaintiff acceded to the fishermen's demand for more pay. But the plaintiff later challenged the enforceability of its agreement to modify the parties' original contract, and the court agreed that the modification was unenforceable. Specifically, the court held that the modification lacked consideration applying the pre-existing duty rule. Under the rule, the fishermen already had a pre-existing legal duty to perform the work at the lesser price specified under the parties' original contract. The plaintiff employer's subsequent promise to pay the fishermen more was gratuitous, meaning that it was not supported by bargain for consideration because the fishermen did not incur a new legal detriment to support the employer's promise for additional compensation. To the extent the pre-existing duty rule makes any sense, it makes sense to protect innocent parties, parties like the employer in this case, against extortion. In this case, extortion by the employer's fishermen employees for a higher compensation. But if the goal of the pre-existing duty rule is to prevent extortion among contract parties, then there are a number of problems with the rule. For one, consideration is a clumsy tool to police against extortion. That is true because a party who wishes to extort a modification can easily work around the pre-existing duty rule. The extorting party can simply offer up some nominal consideration that it provides in return for the modified promise that it extorts. For example, the fisherman in this case could have simply promised that in return for higher compensation, they would brush their teeth at least once a day, something that they were already going to do in any case. Because courts don't second guess the sufficiency of a consideration, any nominal consideration would do to satisfy the pre-existing duty rule. Aside from being a clumsy tool to police against extortion, the pre-existing duty rule presents another difficulty. Because in most situations involving contract modification, there is no extortion. Instead, because of changed circumstances, the contract parties, justifiably and in good faith, want to modify one but not both parties' obligations under the contract. In those situations, the formal requirement of consideration does nothing other than to frustrate the parties' intent to modify their agreement by making it more difficult to modify. Modification becomes more difficult because the parties cannot modify only one of the parties' obligations under the contract. Under the pre-existing duty rule, any modification is unenforceable unless both parties' obligations are somehow modified. The UCC addresses these problems by simply abolishing the pre-existing duty rule in the context of contract modifications. In particular, subsection 1 of 209 reads that an agreement to modify a contract within this article needs no new consideration to be binding. So a modification of a contract for the sale of goods does not need consideration. But in the absence of the pre-existing duty rule, we still need some legal mechanism to prevent extortion, to prevent one party from extorting a favorable modification from the other party. As indicated by comment 2, the UCC uses the implied duty of good faith to serve this function. Specifically, the comment says that an agreement modifying a sales contract needs no consideration to be binding. However, modification thereunder must meet the test of good faith. The effective use of bad faith to escape performance on the original contract terms is barred, and the extortion of a modification without legitimate commercial reason is ineffective as a violation of the duty of good faith. Is it a good idea to dispense of the requirement of consideration? That's debatable. Consider the famous case Roth Steel versus Sharon Steel. The case involved an agreement to modify the price of an existing contract for the sale of hot-rolled steel. In particular, due to a global shortage of steel, the buyer, Roth, agreed to pay the seller, Sharon, more than what the parties had agreed to under their original contract for Sharon's hot-rolled steel. Sharon, however, gave no new consideration for this price increase. But because this is a contract for the sale of goods, no new consideration is required to make a modification enforceable. Remember, there is no pre-existing duty rule under Article 2. So the buyer, Roth, claimed instead that the modification was unenforceable because the seller, Sharon, had coerced Roth's assent to the price increase in bad faith. In particular, Roth claimed that Sharon had extorted the price change by virtue of the fact that Sharon supplied Roth with 1/3 of Roth's annual steel needs, and given the tight market for steel, it was impossible for Roth to get steel elsewhere. The court ultimately agreed with Roth and refused to enforce the contract modification, ruling that the modified price increase agreed to by the parties was not a part of the parties' contract, because Roth's assent to the modification was extracted by Sharon in bad faith. In arriving at this conclusion, note the court used the same two-part analysis of good faith that we have covered in previous videos. Specifically, the court said that in determining whether a particular modification was obtained in good faith, a court must make two distinct inquiries. First, whether the parties' conduct is consistent with reasonable commercial standards of fair dealing in the trade, and second, whether the parties were in fact motivated to seek modification by an honest desire to compensate for commercial exigencies. So the question for the court was whether Sharon, in demanding the higher prices from Roth for the same steel, breached either the objective or subjective components of good faith. With respect to the objective component, the court found Sharon complied with this facet of its good faith duty. Specifically, The court ruled that Sharon seeking a modification was consistent with the standards of commercial reasonableness. Given the changes in the steel market and other unforeseen circumstances, Sharon was operating at a substantial loss under the party's original pricing, and so an increase in pricing was commercially justified. The court noted that other sellers in the same position as Sharon would have also requested a price increase. But with respect to the subjective component of good faith, honesty and fact, the court found that Sharon breached this facet of its good faith duty. In particular, the court concluded that Sharon acted wrongfully and coercively by threatening to stop selling steel to Roth altogether unless Roth agreed to the price increases. It was this coercive threat, agree or else we'll cut you off, that the court ruled creates a rebuttable presumption of subjective bad faith, and the court found that Sharon had failed to proffer credible evidence to rebut this presumption. In particular, Sharon was unable to provide any credible evidence that it subjectively believed that it was legally justified in making this threat to Roth. So the court ultimately held that the parties' attempt to modify their original agreement is unenforceable. Perhaps this is the right result to police against the kind of extortion that the court believed Sharon had engaged in. But as this case demonstrates, good faith is a much more fact-intensive, convoluted, and therefore legally indeterminate tool to root out extortion than the simple bluntness of the common law's pre-existing duty rule. So to summarize, in this video we introduced the topic of contract modifications by reviewing the requirements for modifications under the common law and then examining how the UCC departs from the common law by abolishing the pre-existing duty rule. In the next video, we'll turn to how contract modifications interact with Article 2's Statute of Frauds.